Okay, welcome everybody to our EU Future Talks, our regular online or hybrid event on current developments in EU law of the European Law Department of the University of Vienna. My name is Lena Hornkohl. I'm a tenure track professor here at the University of Vienna, and I'm here with Julia Zechling, a PhD candidate at the University of Vienna as well. Today we discuss the seminal case Österreichische Post that deals with non-material damages for data protection violation. The next one and a half hours we will discuss with our four distinguished experts we have today, which I will quickly introduce. We have with us Petra Leupold, who's a lawyer at the Austrian Verein für Konsumenteninformation, an honorary board member of the European Center for Digital Rights, and also a postdoc at the University of Linz. Welcome. We have Paul Nemitz, who is principal advisor at the Directorate General for Justice and Consumers of the European Commission, and before he was the director responsible for fundamental rights and union citizenship, and the lead director for the reform of the data protection legislation. Welcome, Paul. We have Martin Mekat with us, who is a disputes partner at Freshfields in Germany. He advises clients in complex commercial disputes, including also data protection cases. Welcome, Martin. And last but not least, we have Peter Hense with us, who is a partner at Spirit Legal and advises well-known national and international companies on the implementation of digital business models in the area of IT, data protection, and competition. Peter, also welcome. Before we give the floor to our experts to give a 5-minute take on the judgment, Julia will very quickly introduce the judgment itself. And afterwards, we have prepared a few questions for you, but everybody is also welcome to post questions in the YouTube chat, but please put also your affiliation there. So Julia, you have the floor, and then we will hear the first reactions.
Thank you, Lena. Welcome, everybody. On 4th May 2023, the ECJ handed down its judgment in the Österreichische Post case C-300/21. The facts show that Österreichische Post, as an address broker, defined target group addresses that included, among other data, a statistical probability for affinity with certain political parties. The claimant's data showed a high probability for affinity with the right-wing Austrian Freedom Party. This allegedly caused him great upset, a loss of confidence, and a feeling of exposure. The applicant therefore claimed to have suffered non-material damage in the amount of 1,000 euros as a result of the unlawful processing of his personal data. According to Austrian tort law, mere upset is not a recoverable non-material damage. However, the Austrian Supreme Court was aware that the concept of non-material damage under Article 82 GDPR is to be interpreted autonomously, and therefore submitted a request for a preliminary ruling to the ECJ. The first question was if the mere infringement of GDPR provisions can lead to the award of compensation under Article 82 GDPR. The ECJ rejected this interpretation and clarified that compensation can only be awarded if, in addition to the GDPR infringement, there is actual damage and a link of causality between the two. The third question, which the ECJ answered in the second place, was whether it is compatible with EU law to apply the Austrian tort law principle that the consequence suffered by the claimant must be of at least some weight and go beyond mere upset. The ECJ rejected this as well and clarified that there is no threshold of seriousness concerning the award of non-material damages. The second question asked whether there are any EU law criteria other than equivalence and effectiveness that have to be taken into account in the assessment of damages. The ECJ essentially denied this as well, stressing that the domestic rules for the assessment of damages apply as long as they ensure full and effective compensation. Now, as Lena mentioned, I will give the floor to our speakers for 5 minutes each. Please try to keep within the time limit. Please give us your thoughts on the case and your first impression of the judgment. Petra Leupold, you have the floor.
Okay, now this works. Thank you so much, Julia and Lena, for having me. I'm excited to be here and to contribute to this panel today. And this might not come as a surprise. I'm actually quite happy with the judgment issued in the Post case, especially that the court did not follow the Attorney General's opinion, which, and maybe we talk about this later in more detail, which was actually, I think, unfortunate indeed, both doctrinally and, of course, from a practical consumer protection point of view. So I'm very excited about this judgment, also since it is the very first one on emotional damages under the GDPR, and it is of absolutely significant importance, both with respect to the effectiveness of private enforcement under the GDPR. It's also important concerning the development of a coherent system of EU liability law as such, like more in general. And it also is important because it lays the groundwork for cross-border collective enforcement and multi-state and union-wide redress actions under the new RAD regime, so the Representative Actions Directive regime. I also do think it is legally actually sound and compelling, in fact. We mustn't forget that Article 82 is provided for by a regulation. We're dealing with a regulation, not with a directive here. And such an introduction of a minimum threshold under national law clearly defeats the full harmonization character of Article 82. It's not reflected in the wording of Article 82, nor its recitals. And it strongly contradicts the objective to strengthen and not to weaken private enforcement. I also would like to stress that, of course, it would have ignored the compensatory function and ratio of Article 82. So one more aspect legally, which is highly interesting, and I guess we'll talk about this in more detail later. It's especially important also because we are dealing with the compensation of non-material damages pursuant to Article 82, which is based in primary law. Like it's reflecting actually Article 8 of the Human Rights Charter. So this means we're talking about a fundamental human right and its violation. So in conclusion, I basically agree with all of the court's holdings regarding the rejection of a threshold. The emphasis also put on the principles of equivalence and effectiveness, which actually have been crucial in safeguarding a full and effective application and compensation of the law in other fields of the law. There are just two more points I would like to touch upon very briefly as regards the consequences of the ruling and the background of the case. First of all, as I pointed out before, the practical relevance of the legal issues in question and of the judgment, in my opinion, cannot be overrated. Many, if not most, of privacy violations do not have tangible financial consequences. They do not entail any material damage on the part of data subjects harmed. So this means if it weren't for the compensation of non-material damages, privacy rights violations basically and as a rule would not have any liability consequences at all, which kind of defeats the very existence and objective of Article 82. Also from a practical point of view, a gravity threshold would have been quite counterproductive for legal certainty, very difficult to determine and actually outright deterring for data subjects to pursue their rights in court. In Austria and Germany, particularly prior to the ruling, what we observed was a strong tendency of hesitance of the courts to grant compensation for non-material damages. Many cases were actually dismissed for no good reason except for a lack of gravity of the emotional distress caused. This partly can be traced back to a private law doctrine and a strong legal tradition that grants compensation for non-material damages only in cases where explicitly provided for by statutes. And additionally, of course, we see that courts face apparent difficulties in determining the existence of non-material damage when there is no physical or tangible injury, such as a broken bone, or when the emotional distress has no physical manifestation, is not actually exacerbated to a degree that reflects an actual mental health issue. And of course, and this is one of my final points, the same is true concerning the determination and calculation of those damages. Just like in any case of immaterial damages, those damages are hard to quantify because, of course, they per se cannot be measured in monetary terms. So consequently, I believe the follow-up question and the real question now is how, in practice, to establish the existence of damages, how to quantify those damages, and especially how the principles of effectiveness and equivalence have to be applied in accordance with union law, and how the European Court of Justice will proceed to construe those and apply those principles in the field of data protection law under Article 82. For Austria and for now, the application of the principle of equivalence is actually of particular interest. Because we just talked about this briefly before, concerning physical harm and bodily injury. Austrian courts developed and apply kind of informally, like pseudo-formal, standardized guidelines with respect to compensation of pain and suffering. And we have the practice here that non-material damages are awarded regardless whether the harmed person is more or less sensitive to experiencing pain than average. In fact, we have a decision issued by the Austrian Supreme Court that awards non-material damages also in a case where the effect that the harmed person wasn't actually able to feel any pain at all. So this is very interesting, and in my opinion, it might be that the principle of equivalence plays out insofar as this line of reasoning and this case law is to be applied to non-material damages following data protection violations as well. So in other words, and this is a brief conclusion, I think the effectiveness of the right to compensation still heavily depends on the case law to come, both of the national courts and of the European Court of Justice, and how the court will substantiate and flesh out these principles of effectiveness and equivalence. We have already seen that the court developed a very rigorous and liability-friendly approach in other fields of law, especially in consumer law and in competition law. And what is highly interesting in this decision is that the court actually references the leading case, the Manfredi decision in competition law, when it comes to like kind of fleshing out a very effective approach to liability in competition law. So this would be a very plaintiff-friendly interpretation if you apply like case law issued in cartel cases and in consumer law as well. And on a very final note, I already mentioned this briefly, the decision ensures GDPR's enforceability by individuals, which is highly important, of course, and in line with the rationale of the GDPR. But, and realistically, way more important, it also enhances or ensures enforceability of the GDPR via collective action. So we have, as I mentioned before, the Representative Actions Directive, which will enter into force or will be applicable as of June 25 this year. And it references the GDPR in its annex, so it applies to GDPR violations. And this is, of course, like one of the prerequisites of enforcing the GDPR via a representative redress action, that there are actually compensation claims which can be enforced, and the more harmonized and unified those compensation claims are across Europe, the more likely that representative actions can actually be conducted in order to enforce those rights. Thank you.
Thank you very much. Very interesting points. Paul Nemitz, would you like to continue?
Yes, thank you very much. I concur that this is a very important judgment, especially also in the points in which it is different from the opinion of the Advocate General. I think we live in a time in which we have to rethink the right to compensation of immaterial damage in view of a new dimension, namely this dimension being at the center of this case, namely the infringement of a fundamental right, which is happening millions of times, maybe hundreds of millions of times a day, and becomes a complete routine in the data economy. So all these small infringements of fundamental rights, and I'm not only talking about the right to data protection, I'm also thinking, for example, the whole phenomenon of fake news. We live in a world in which the readiness to break the law, especially in the digital economy, is large, exactly because on the one hand, no material damage can be shown on the side of those people whose rights are damaged. And on the other hand, hundreds of millions and billions of euros of profits are made by the companies from these distributed breaches. So I think the challenge here is to rethink civil liability, or I wouldn't even call it civil liability, I would call it damages law, because that's the terminology of the regulation. Damages law in the area of personality rights and fundamental rights. And so what is clear from this judgment is that the court does not follow the school, which is it's all a matter of national civil law. And because we have a tradition in civil law where it may make sense to have a certain threshold, we just transfer this thinking to this very important area of protection of fundamental rights. So I think this old thinking is finished, and it's important that it's finished, and that we move to a new thinking on damages which serve to compensate the damage done to individuals in the breaking of their fundamental rights, which is becoming a mass phenomenon in our societies. And the drama of the case is, I would say, that the type of information which has been collected and processed here by the Austrian Post, namely political orientation, is among the most sensitive. I'm actually surprised to see that in the judgment, Article 9 of GDPR is not mentioned, because the type of information we're talking about here, political orientation, well, you know, that is the type of information the Nazis tried to find when they were scanning public libraries. And the Austrian Post was basically holding ready a register, which, you know, if a certain party comes to power, it could be used also in the other way. So it's a dramatic case of something which should absolutely not happen. And if I understand things correctly, the Austrian Data Protection Authority has actually as its biggest clients in terms of fines already the Austrian Post. So from a public enforcement point of view, this is good. But this is not enough. And now let me say, I'm not talking here about the punitive function, to be very clear, of damages. There is no need to go there. But it is important to recognize that in the GDPR, consciously, and in very big difference, for example, to the AI Act, which is now going forward, a double avenue of protection of rights has been set up. On the one hand, the way via authorities, which can fine and take other actions, not only fine, but also can ask for deletion and so on. This is the, let's say, the administrative way. And on the other hand, the way via private enforcement of rights. And again, both split, not only the right to reach compliance, so cease and desist orders and so on, but also damages. And this is very important because we live in a world in which it is the standard practice of big tech, big business, in particular in America, whenever a new law is made, which is good for the people, and Congress has a hard time to do this already in the area of digital, we see not much happening there in America. But if there is a discussion, the first point is of the business is no private enforcement. And of course, there are people who try to carry this to Europe and say, well, you know, it's already good enough, the fine of the public authority, we don't need and we don't want private enforcement, and all of this is anyway punitive, and that's not what the law foresees. I don't think this is the way we should follow. I think we have to take serious the harm to people which is done by not respecting their fundamental rights. And this is immaterial damage, as I said, with which huge profits are made. And it's not punitive to say that the people who make money with this, they have enough money to pay. Their business models will not, unfortunately, be completely destroyed. You know, you couldn't impose sufficient damages for that purpose. Because most of these cases are just not caught. But when there is a person who says, I have a bad feeling about being profiled as a member of this or that party, Article 9, sensitive data which should get extra high protection, we should ask for the reasons why, and because this is the type of data when it is saved, which creates what the Court of Justice called the chilling effect. If we live in a society where people know that their political affinities are profiled, that will hurt them a lot. It will impede them from a lot of things what they would like to do in terms of availing themselves of their fundamental rights in other areas. So I must say, I completely understand that a lawyer who understands these connections says, I really felt bad on a daily basis. And it is good that the Court of Justice does not require, as the opinion of the Advocate General in, you know, I would say, classic civil law argumentation has laid out, that you have to present first the bill of the psychiatrist before you can ask for non-material damages here. I think it is good that the court has stuck with the wording of GDPR, and the wording is intentional, because the fundamental rights are something which are important to the individual personality, to the building of humans. The fundamental right of data protection and all other fundamental rights are part of our personality. And it does hurt people, and I have no problem to understand this. No problem whatsoever that it hurts people if they think they have a constitutional right and they don't get it. So let me close by saying, I think now the challenge is to operationalize this new thinking in jurisprudence by national courts, but also in academia. I think we need two areas of further research. First, what is actually the situation in member states as regards non-material damage for the infringement of fundamental rights, and this in a comparative perspective. And second, we need work which gives good advice to national courts, how to explore and develop a new jurisprudence which makes living with fundamental rights in the digital age a reality. Thank you very much.
Thank you so much. Martin Mekat, please, your 5 minutes.
Yeah, thanks, Julia. And I mean, it's interesting. I think sometimes you come into these situations, and it may also be to the fact that I'm a little bit in the opposite camp of my three co-panelists here. That it's like a football match where you see a match, and then you see like very differing views afterwards from trainers or players or otherwise involved parties. And here it's quite interesting because I think in many aspects we're probably concurring. I agree it's a long-awaited decision. I would say that the content, as you have explained it also in your summary, Julia, is probably not that surprising. It's actually surprising how long it took, and I think it also probably will need much more time. If you think about it, it's the Austrian Post case is like the first out of 16 referral proceedings on the interpretation of Article 82. Peter and I recently met in court, and we talked about like these various different referral proceedings. And he said that he prepared like a little map showing how much overlap there is between these different referral proceedings. And I think it will take a lot of time until, at least on a European level, many questions are clarified, and even longer probably on a national level. And probably what my take is, I mean, am I happy about this decision? I think it's good that we actually have it, and it's also like good that we have this clarity. However, in terms of like interpretative guidance, I think the ECJ has not gone far enough. I mean, we have like a certain interpretative guidance. The mere provision is not enough, and there's no de minimis thresholds. And like for financial assessment, it's the member states' national laws under consideration of the principles of effectiveness and equality. However, I mean, there is, and I think Petra alluded to it briefly, there was way more content in the opinion of the Attorney General. And I mean, the question is whether you think it's right or wrong, but the position that the ECJ has taken is a rather diplomatic one, where he said, and sometimes it's a bit, sophistic in terms of like approach, that he said, well, we have this European autonomous concept of damages. However, we have no like clear wording except for a few mentions in the preamble, and therefore I refer it to the member states to fill this void. And actually, this is something where I think, I mean, it's a bit of a lost opportunity where we could have seen more, because I can tell you, at least in my practice, I see tens of thousands of cases where many of these issues that the Attorney General has mentioned, be like loss of control, and these areas will still be up for decision by the courts in Germany. And we have seen cases going in different directions, and we are far from like having a uniform body of case law. And maybe a quick comment on what Paul has said in terms of like the liability concept. I'm not sure if I agree with, like, at least based on my reading of the ECJ decision, because I mean, among the few things that the ECJ has said, he has said that he believes that Article 83 and 84 have a punitive nature and are different in concept. And it's like among the very few elements actually where he has been very precise. I mean, these are things that we have seen over and over in German courts. Can't Article 83 and 84 be used like for assessment of damages? But it's something where the ECJ has now said no. And in terms of like which level of harm is now enough, I mean, we have his statement on de minimis. On the other hand, he says that a mere feeling of discomfort is not enough in itself. It needs to be seen whether this constitutes harm under the national laws. And I mean, I fully agree with Petra that the traditional role, at least in Germany, is a very restrictive one. And it needs to be seen how this adapts, because the test that the ECJ has put here, whether like effective equality and effectiveness are triggered. I mean, this is a very difficult one. If you look at how it's worded, it says like for principle of equivalence, whether the situation is less favorable than in domestic contexts. So basically, it's a comparison between like national law or purely national cases and EU cases, which is probably, at least in Germany, mostly not relevant. And then the other case for like effectiveness, which is hugely important. I mean, it's defined in a negative. It says, I mean, as long as it does not make it excessively difficult or impossible in practice to exercise the rights conferred by EU law. And I mean, these are like tough benchmarks to hit. So I am quite curious of like what the national law courts will do with it. But I think based on the ECJ decisions, I think it's not as clear as Petra and Paul think it is. And also in terms of like where we are right now, there's a lot of like subjective elements, and we had this briefly in our pre-discussion before the call. There's a lot of subjectiveness about this, who was like harmed in what way, and to see how these things are brought in like representative actions. Let's see. I mean, similarity is also a requirement. We've seen case law. So far, the courts have been rather lenient and appreciative of like claims being permissible, but I mean, there's still a lot of points to argue and dispute about, and yeah, I think there's still like way to go. With that, I'm handing over to Peter.
Thank you so much.
Thank you, Martin. Thank you, everyone, and thank you for me having the ability to speak in front of such a great audience. My thoughts. So I think Österreichische Post marks a milestone in the evolution of European law on damages, because it's kicking off the era of private enforcement of privacy and data protection laws. And given the clear failure of DPC Ireland in enforcing GDPR, this is good news for law-abiding citizens. The judges of the ECJ, they breathe new life into the centuries-old Roman legal principle of restitutio in integrum, and they are adapting it to the unique challenges of our digital era. In the 19th century, let's go back a bit in time. So when much of our civil law was established, our concerns revolved around liability for issues like anthrax, infections from infected goat hair in Germany, or phosphorus-induced necrosis of the jawbones in match factories in the UK. Back then, legal discussions hinged on causality and vicarious liability and rules of evidence. Today, we grapple with illegal business models that exploit consumer data for profit. Well, that's not the same. So the health and privacy challenges we face today require an adjustment of both laws and minds. And the CJEU has shown its awareness for our common legal traditions and applies Europe's traditional legal principles to the TikTok and generative AI era we live in. The principle of restitutio in integrum has always been a guiding concept for compensation all across Europe, asserting that harm caused by an unlawful act should be rectified as far as possible, restoring the conditions that existed prior to the unlawful act. So in Österreichische Post case, it's illustrated how this principle can be applied to data protection violations happening on a daily basis now. The court has made it clear that the protection of individuals whose data has been unlawfully used must be the priority. That's a very important part of this decision. Moreover, the ruling, it underscores that compensations provided by those responsible must be sufficient to fully rectify the imbalance. That's where the restitutio idea comes into play, to rectify the imbalance caused by the violation. And the evolution of damage law in the 20th century included already significant adjustments to mirror societal and economic realities. A notable example is Germany's concept of compensation for lack of enjoyment of holidays. This shift was led not by lawmakers, but judges who recognized the need to compensate hardworking people for ruined package holidays. Interestingly, these early rulings saw wasted vacation time as material damage. However, the discussion on compensation should not focus and not be limited to a German or Austrian perspective. the distinction between material and immaterial damages isn't rigid or a divine decree. It's more nuanced than that. Comprehensive compensation or restitution includes the real costs of lost time, additional stress, missed work opportunities, and actual legal costs, not arbitrarily capped ones as in Germany. These are material damages, on top of which immaterial damages are added. So the ECJ's ruling in Österreichische Post is a clear example of this holistic approach to compensation, because the court emphasizes that compensation must be adequate to fully correct the imbalance caused by data protection violations, indicating that such violations have both material and immaterial consequences. If compensation for a ruined package holiday is justified under the Package Travel Directive, see the Leitner decision in 2002, then enduring the nightmare caused by data abuse deserves full compensation too. This means the rights of individuals whose data has been unlawfully used must take precedence over the hurt feelings and emotions of representatives of companies that caused those damages through unlawful negligence or even intent. In the coming years, and that's where I think you started the discussion, the new European collective lawsuits, they will change the legal landscape for the better. After all, large-scale legal violations can only be countered by large-scale legal defense. This is a simple economic truth. Thank you.
All right, Peter, thank you. And thanks for this first round of reactions. I think we have some agreements, some disagreements, and to further go into these different topics of the judgment, I think what is clear was what came out in the judgment, okay, we need full and effective compensation. We hear that a lot of time from the Court of Justice, but maybe you can allude a little bit what this should mean in practice. And I think also from a procedural perspective, and Petra, you've mentioned that before, the court has these parallels to consumer law, to competition law. And there, the principle of effectiveness has been used to create procedural tools, such as, one thing that could be used here is the possibility to estimate damages, or Peter, you have just mentioned it, this imbalance. So can the principle of effectiveness be used for information access purposes? So I think, what, in your opinion, what could that mean, full and effective compensation? And maybe Petra, you start again, because you've also mentioned it in your intervention.
Yeah, thank you very much. Yeah, so I was actually really excited reading the reference of the Manfredi case, and also that, as I pointed out before, the court actually put an emphasis on the principle of effectiveness in that context. And of course, as you just said, Lena, there is case law already in with regard to competition law and consumer law, both with regard to substantial issues, as well as with regard to procedural implications, to enhance the possibility of data subjects in this context to have a right to effective compensation. I guess, and this also is something I think Martin mentioned before. Of course, we don't have legal certainty as of now where it will lead us in the realm of data protection law. We can only guess so far, and I think it will be a very important task of national courts to refer more cases to the European Court of Justice in order to give him the chance and to get legal certainty for all parties involved on how to actually apply especially the principle of effectiveness in this context. So if any indication, and I think that was your question, if consumer law, case law, and settled competition law, case law is of any indication with regard to the interpretation of Article 82, I think it's also very interesting that we have those strong procedural implications. So there might be an ex officio obligation of the court, of the national court, to examine possible violations, of course, but also to generously apply, for example, in Germany, Article 283, in Austria, Article, I think, 287 of the Civil Procedure Act allows for the estimation of damages, and you mentioned that. And of course, with regard to non-material damages, this is crucial because they per se cannot be measured in monetary terms. I think it's important to make more generous use of this rules in the existing procedural framework than has been the case so far. What I think Martin mentioned before too, I think is very interesting. This one sentence in the court's decision with regard to that, like, kind of subjective feelings alone might not suffice in order to establish the existence of non-material damages. I think that might hint to more objective criteria, such as the duration, the gravity of the violation in question, the kind of personal data that is actually affected. Paul mentioned Article 9. Actually, it's a dramatic case, right? I mean, it's really sensitive data that's concerned with regard to the political affiliation. So there might be criteria, and I do hope that the court will substantiate in future rulings what objective criteria might be in order to determine maybe also like kind of a rebuttable presumption of the existence of damages, which of course the less subjective the criteria are with regard to a presumption of the existence of damages, the more likely for collective action, because of course, like I think this was, like cross-examining each and every data subject for collective enforcement, and this is something Martin mentioned. I don't see a similarity problem with regard to the admissibility of redress actions with regard to that. I also don't see a jurisdiction issue, which is a big step forward compared to, for example, the Facebook Austrian-style class action Max Schrems tried and failed notoriously with regard to the European Court of Justice decision concerning Brussels I, the interpretation of Brussels I. So it's not so much a similarity issue under the Representative Actions Directive, but it's more the question if there are actually qualified entities that pursue those rights in actions launched, because they have limited resources as well. So the more individual and the more resources it takes to launch those redress actions, the less likely that NOIP or in Austria VKI or in Germany VZBV will take up those cases, right? So I think this is something to look at in further case law. And it's also something where competition law, of course, statutorily here in the directive now as well, has this assumption and the presumption, the rebuttable presumption of existence of damages, right? So I do hope this is the direction the European Court of Justice is moving its case law in the realm of privacy law as well.
Good that you mentioned the directive, Petra. This was just something I wanted to ask Paul. I mean, now we have a little bit of uncertainty. We have the full and effective enforcement of data protection law as a principle, and you could say, okay, the court needs to further develop also procedural tools. But Paul, do you think maybe next to Article 82 GDPR, we need a data protection damages directive that gives these tools, like it was done with competition law? After the Manfredi judgment, we had the directive that provides the presumptions and the estimation rules Europe-wide. Do you think that's a possibility, or what's your opinion?
Well, certainly it's a possibility. I mean, there is certainly a legal base for that, and the Commission will drum up useful projects for the next mandate. And I think anyone who wants to write about this now and make the argument that this should be a project for the next mandate of the Commission is certain that it will be read in the Commission, and it depends a lot on the next composition of the European Parliament and the European Commission, and also on the person of the Commissioner for Justice, whether this is something which will be taken up or not. But it's certainly not something which is totally out of this world. As you said yourself, the parallel to competition law is evident, and I would say the problem here is bigger, because in competition law, after all, we're talking about material damages. Here we talk about non-material damages, and so in the spirit of what I said before, namely that we have to, adjust the thinking of judges and reshape our world according to the challenges of the digital, including, the mass impact on fundamental right of digital business models, which are predatory. The Commission has shown that it's willing to do legislation which addresses these issues and sets a framework. And I don't think that one can assume or must assume that this willingness will just disappear in the next mandate. I think in this mandate, it will not happen. I think we will watch now a little bit how this jurisprudence is implemented. But I would say that, it's also the hour of academia to provide, on the one hand, from a normative point of view, the advice, what should be done now. And on the other hand, also provide the empirics on what is actually the situation in member states and what will it lead to if we do nothing. So we are not here in a situation that we have to now wait for 10 years, but if there are good studies coming up which clarify what this judgment actually means in terms of applying national law, and if we see that there are huge divergences, that is of course an argument, because that comes back to the functioning of the internal market. If we have huge divergences in the risk of having to pay damages for non-material damages under Article 82 between the member states, it has an impact in the competitive relation between these member states, and this is something which the Commission would normally address. So, I think these findings now have to come on the table, and I'm very interested to read these things, and I'm sure others in the Commission too. And so the door is open. This being said, I think in damages law, a certain degree of unforeseeability is also not bad. The same applies to fining law. If all the fining rules and all the damages rules are in the end mathematical formulas, and fortunately the Court of Justice has said that we are not obliged when we fine in competition law to do it according to a mathematical formula. But if it would be so foreseeable that it all becomes a mathematical formula, it becomes a cost of business and is just circled into the business model, and it doesn't have the deterrent effect which we seek from it. So I think we can and must live with a degree of deterrent and thus a degree of unforeseeability. But on the other hand, if the divergences between member states are too big, there is certainly a case to be made for EU action.
Thank you very much. So we have talked a lot about digital business models, and also that big-scale data processing needs to be countered by big-scale legal enforcement. So do you think that the judgment could be the starting shot for new business models for the collective enforcement of non-material damages, similarly to the Air Passenger Rights Directive, for example? Peter Hense, what is your opinion on that?
Yeah, thank you. Good question. There are certainly people who think that this is the kickoff for a new era of mass litigation in data protection law. I don't think so. The uncertainties are still huge. It will take at least another 5 years and another 10, at least 10 decisions by the CJEU until someone says, okay, I'm going to invest, say, 100 million US dollars or euros into vehicles that are have one purpose only, like a mass litigation. We will see NGOs doing that. We will see maybe your Austrian or the French or German consumer protection agencies doing that, shaping the battleground. But it will take a lot of time, and we will see many like victories or defeats in court according to the perspective. Martin just gave us a little bit of perspective on that. Of course, not every damages case is welcomed with open arms. From my perspective, we have still a lot of open questions that need to be answered first, and some of those are how can we apply the trinity of the DSARs, data subject access requests, plus the cease and desist, plus the damages actions in order to make this work. As with respect to the Manfredi decision and the cartel and antitrust damages, I think, I would say I already see that data protection considerations are currently rather being added to antitrust damages cases, more so than the other way around. I mean, at least we are working on it currently. So,
thank you very much. Martin, Mekat, what is your opinion on these business models and also the challenges maybe for the defendant side in facing huge mass actions in the future?
Yeah, thanks, Julia. I would say it's, to start with, I agree with Peter's view that there's like a lot of open questions. What I would disagree with is like what has been said just a while ago with the starting point. I think the starting point has already been, has happened or has occurred already in the past. I mean, I see bundled actions for like thousands of data subjects' rights. And I think it's only a matter of time when we will see representative actions occurring, and this is something which is completely unrelated, or at least somewhat unrelated to the Austrian Post decision, because this is based on the on the Representative Actions Directive, which was already decided like roughly 2 years ago, and therefore I would say first things these things have already happened. I mean, many of the plaintiff firms that have done diesel emissions litigations a few years ago are now venturing into the privacy litigation sphere, and they're not as skilled as like real privacy litigation boutiques, but they're seeing this as a very interesting business area and business sector, and yeah, it's something where like companies who are involved in this field will see this more and more and more. And maybe one word quickly on Paul, where he said that that he wants to deter defendants and punish or penalize predatory business models. I think that's part of the truth, because we have many cases in which it's not about predatory business models, where it's about like data breaches, where companies have become victim, and then you can argue, should they have been more diligent? Where the measures of protection, the technical and organizational measures, were they good enough? That's something that you can argue about, but it's not always the case that someone needs to be penalized. And I think the ECJ has made clear that it looks at the compensatory nature of the damages claims, which should be in the focus of these actions. But the more players you have, and I'm not really worried about like these traditional NGOs, be it like BV in Germany or similar organizations elsewhere. It's more about like the plaintiff, professional plaintiff players who, and I don't think that they need 100 million euros, the figure that was dropped earlier. They need much less, and they will look for their return of investment. We've seen over the last 2 years a steep incline of these cases, and I think this will go on for some future time. Yeah. Not sure, did this answer your question, Julia?
Sure. Petra,
Yeah.
do you want to react? Yeah.
Yeah, thank you very much. I'd just like to briefly comment with regard to this issue. I agree that I don't see it happening, like new business models right as of now, and this judgment being kickstarting this new era of mass claim litigation all over Europe. For once, I also don't see that happening under the new RAD regime, because as we know, the standing for those new representative actions, also the redress action, is limited to NPOs, NGOs, where it's more a bottleneck kind of issue that we actually have enough of those lawsuits. It's a financing issue, it's a resources issue, and I'm not worried about the other end of the spectrum where we have nuisance suits and mass litigation all over Europe. With regard to assignment solutions, which of course are also possible in the data protection field, I do think, I mean, there are jurisdictional issues. There will be some kind of forum shopping possibilities under the current framework of Brussels I. Yeah, I mean, mainly there are jurisdictional issues. So I don't think this is like the parallel regime where private players will make huge profits in the near future. However, and this is an important point, so I don't think anyone has anything to worry as of now, right? But I do want to emphasize that I get the impression that focusing on these kind of worries, or also Martin kind of elaborated on that a little bit, focusing on like a mere hypothetical threat of importing a kind of US class action culture and mentality and class action threat is kind of missing the point totally, because as of now, with regard to consumer law enforcement, as well as especially GDPR enforcement, we have a striking level of under-deterrence when it comes to the level of enforcement. So we are not close to a level where we would discuss an adequate level of enforcement, much less a level of over-deterrence, right? So it's the other way around. And I think this is really important. And one last remark, because I think it's kind of a little bit like a cynical discussion, and I don't, like, I look to Martin. I know you didn't say that actually, but it usually, like, the argument goes that way. I cannot see why it actually would be immoral per se, or an abuse of justice, or detrimental to the justice system to make financial profits. Like, if there are actually players who try to litigate for financial profit, I mean, in the end, enforcing consumer rights is the goal. And we do know this, like, litigating for profit kind of system, it's a reality of attorneys, right, in our justice system. So with regard to third-party funding, and this is a bigger issue also at the European level, I'm aware, apart from the GDPR issues, but I do think there are a lot of misrepresentations actually going on. So I just wanted to address it briefly. Thank you.
Thank you, Petra. I think now it would be good for Paul to react also to what Martin has said regarding the deterrent effect. So the court said there's no punitive damages in GDPR, but then with any damages, they can have deterrent effect. So can you maybe allude to what's the difference in your view of having punitive damages, deterrent damages? Yeah.
If I may start, well, I think that deterrence as such, I mean, it's we need to be careful not to go into semantics. I mean, how I read the court is basically punitive damages are off the book. They're not part of the European regime, and they also say it's not in line with like how our European systems work. And what they say is that damages need to be fully and effectively compensating. So what the principles that Peter mentioned that go way back, which are like fully restituting or repairing the harm which was done. However, deterring someone for behavior beyond the pure financial repair of harm is something which I don't read as covered. Because I mean, if you want to deter someone, I mean, then you can like then fines can be issued, which may have a deterrent effect. And I think that's pretty clear from reading Article 83 and 84. However, the deterrent effect in these civil claims, I don't see a European basis. And also like from a pure practical point of view, I think it can hardly be done in a sensible way. Yeah? Because if you look at the civil judge, be it in any big German city, be it like Frankfurt, Munich, Hamburg, Berlin, Leipzig, wherever. How is this judge supposed to come up with like an appropriate amount of damages that should have a deterrent effect that then is in itself sensible? Because the judge in itself, he has no clue and like also no possibility of ensuring that this is an overall sensible solution to this overall topic. I mean, this is just not possible, and that is therefore why it's actually the right thing to put this in the arms of the data protection regulatory authorities, who can then issue fines. Maybe they're not doing this enough, and this is like topic for another debate. However, I don't think this is something that should be governed by rules on damages, which are compensatory in nature. Yeah.
How are your reaction to this?
Yeah, I would say simply that if we have full and effective compensation of immaterial damages, from a systemic point of view, this will have a deterrent effect, because the companies who until now get away without having to pay any damages, and we're not talking about punitive damages, but just the damages which are due under these rules, of course, they will figure this into their business model. So I think it's not of the devil, and we're all allowed to speak of the systemic intention of the GDPR, because on the one hand, of course, this is about compensating individuals. On the other hand, it's about making the system as a whole work. And the system does not foresee that, for example, once a fine has been paid, on the damages afterwards, we can take it easy. Not at all. The system foresees full and effective compensation. Doesn't matter whether the company already has paid, 20 million or 19 million, as in this case, I think, in fines. So I think from a systemic point of view, therefore, it is absolutely legitimate to talk about the systemic need to now implement with rigor and with seriousness the provisions on full compensation, because if judges don't do this on a broad level, we are losing the deterrent effect which the GDPR wants to see. This being said, I think it's true that this doesn't give guidance to the individual judge beyond generally encouraging him or her as a judge not to be shy on these matters and to take the matter seriously. So I think we also need to become a little bit more, let's say, honest on explaining what type of damage and how they could be calculated in an objectivized way. For example, in some member states, there are tables, when you lose a daughter, and they then help calculating, how much time better is, a brother. You lose a brother, And in some member states, you have tables which say, well, you know, the non-material compensation, damage compensation, which you get, depends on, you know, how much holiday did you spend with the brother, how much time, how often did you telephone, how old are you, and how old was the brother, and so on. So I think if we think about, let's come back to our lawyer who doesn't want to be profiled as a member of a certain party, which he thinks is, you know, beyond the democratic spectrum. I think that was the issue here. I think it was the FPÖ in question here. Well, you know, a judge, of course, could look at, you know, how politically active was the claimant, how much would this claimant, you know, suffer if the information came out. You know, how much can we believe that the claimant really knows about its rights, and so on. I mean, you know, I must say, I have a great sympathy for this lawyer, because it's not a nice thing to know that the FPÖ holds this, is in the storage of the Post and can come out any day. And even if it didn't come out, it may have had a chilling effect, and it may have caused daily pain. And we know that there are tables for, you know, daily light pain, daily middle pain. So the chilling effect, as the court has said in the judgment on the data retention, the chilling effect, the knowledge of people that their telephone calls are logged, not the content, but the fact that they called from where and how long and whom did they call, has a chilling effect on their exercise of other fundamental rights. You know, I'm sorry, I mean, you know, there are a lot of criteria which we can give to the judge already now to put a hefty sum of compensation on this. Because in the end, for people, it makes a huge difference whether they live in a world like China, you know, with social scoring and being herded by machines and by artificial intelligence, or whether they live in a free society. And we know also from the interviews, from people who lived in communist dictatorships, from people who lived in the Nazi time, we know how much also physical pain people suffer if they know that with such information you can go after them to take just this precise information again. And that's the reason why political orientation is among the most sensitive data in Article 9. So for me, it's very clear, any type of breach related to sensitive information, of course, must get a higher compensation than the breach in relation to other damages. And let's take this serious. And let's not talk about it as if it's just nothing and it's just normal in our world and so on. This type of talk devalues democracy and devalues fundamental rights to something which in the end we will not altogether value anymore. And that's exactly where we don't want to go.
Thank you, Paul. Petra, you wanted to react?
Yeah. No, I fully agree. I just one quick comment on the issue, punitive damages versus non-material damages, and the meaning of that. I think it's also with regard to the Attorney General's opinion. I thought all this focus on punitive damages. So I'm very happy that the court in the judgment, actually, I think it's only one sentence with regard to punitive damages, right? While the Attorney General, it went on for pages and pages, right? So I think this is actually beside the point, and it's very important because it's a little bit of a smoke grenade psychologically. Like, it looks like a maneuver against a broad interpretation of Article 82, but I think it's misguided, right? It's not legally sound, because no serious scholar I was talking to, no one seriously disputed that Article 82 only awards damages, right? It has a compensatory nature. No one actually argued for punitive damages awarded under Article 82. So you need to really differentiate between non-material damages, which is just like material damages, and their compensatory nature, and on the other hand, punitive damages. When we think of the US, the triple damages, and whole different legal tradition, right? So it's not really, it was not really argued for under Article 82 in the first place, which, and this is important, does not mean that enforcement of Article 82, so the actual award of non-material damages under Article 82 in practice, actual enforcement, of course, has a deterring nature, right? It's preventive. It also is useful to prevent future violations, because as we heard from Paul, of course, if there are any consequences at all, meaning fines and or also compensation to be paid, it's like a cost-benefit analysis, and it disincentivizes efficient breach of law, right? So of course, the whole approach that GDPR has taken, which is this combination of public enforcement on the one hand and private enforcement on the other, this perfectly fits. It's not a contradiction. It's not mutually exclusive, and it's a normal complementing function of damages, also Austrian and German damages law, that it also, of course, has a preventive nature to it, which isn't to be mistaken for a punitive character. And one last remark with regard to, I think Martin stressed that public enforcement would be more adequate here to deal with, like, non-material damages. I mean, I think there is a reason why the European legislator in the GDPR followed this model, this combinatory approach of having public enforcement on the one hand and private enforcement on the other, because as we see and experienced since the GDPR actually entered into force, we see an overwhelming deficit of public enforcement. So this is actually really striking, and there are several reasons for it, but there was also good reason for the European legislator to kind of anticipate that, and with combined forces, public and private enforcement, try to ensure a better, more adequate level of enforcement.
Thank you,
Maybe if
Peter. Martin, you
can I
want to
short-
quickly react, yeah?
Yeah, yes, a very short right of reply. Yeah, I think we're getting a little bit into the semantics here, because the deterrent effect, I mean, if it's just like based on what is compensation as such, I mean, it is obviously still there, and maybe part of companies like evaluating damages. However, but and this is like my practice. I mean, day in, day out, I see cases where like people ask for like loss of control cases, amounts in excess of like 5,000 euros, arguing that it's not about like the harm suffered, but rather about like a necessary deterrent and punitive measure beyond that. And this is something which you may not, and I'm glad, Petra, that you don't see any reasonable scholar holding such view, because this is exactly my point of view. But this is what we see day in, day out in court, in privacy litigation matters, and therefore it's highly relevant to what courts need to struggle with and need to consider in their decisions.
I just want to add, I mean, this is, of course, from a pathological point of view and perspective, like we're on opposite sides of the spectrum, right? And it's important to have different perspectives from the pathological cases that we experience in practice. But I mean, this, in my opinion, is no different than in any other field of law, where we just need consistent case law that will need to be established by the European Court of Justice, and which probably will go down the route small damages, like little harm, small damages, bigger harm, bigger damages, right? And this is not unique to the privacy field, right? I mean, this is the same with regard to pain and suffering when you have bodily injury, like physical harm. You need to kind of measure that as well. And if you have a mass accident with where a lot of people are injured, I mean, it's the same problem, right? So I don't think it's unique, but it's new in this area. Yeah.
Thank you. We have one question from the chat before we have to go to like a last round from everybody. But the question from the chat, we also ask ourselves this, and it relates a bit to this public-private enforcement debate we are just having. Somebody was asking whether you see the danger that this judgment will lead not only to the very different legal calculations of damages in each member state, but also the political danger of compensating dumping to attract tech companies. What you see with public enforcement. Maybe Peter, you want to react? Do you see this also from maybe a little bit of a forum shopping perspective, you know, the rules and Brussels 1 for GDPR and also in the GDPR itself for giving jurisdiction are not very clear sometimes and can give the room for forum shopping. What do you think?
I understand that there are fears and also emotions involved, especially brought forward by PR firms that are hired by big tech companies. Speaking from experience, we are currently engaged in litigation in around 45 collective cases pertaining to privacy laws, in addition to, say, 100 strategic cases involving individuals. For this new era of collective actions that's hopefully gonna come, I see cases based on mass assignments competing with collective actions. So like a very limited playground for everyone involved. And there and then we will witness a symbiosis of litigation, civil litigation and administrative proceedings, definitely based on the facts of a judgment. The authority, the DPA, can issue a fine or some other measure under 58 GDPR. So speaking from experience, in the future, individual cases and damages will have a very limited role, and the focus will shift towards an understanding of broader societal or group impact and harm, because we will only see like collective actions either via assignment or under the new implementation of the directive. So also in civil procedural law, it should be noted that when the court estimates damages, the risk of excessive compensation lies within the wrongdoer, not with the victim. And it must be clear that data processing inherently carries a risk, which when realized always requires compensation. So factor that in to your business model and you will be fine in the future.
Thank you very much. So time flies by. We actually only have 10 minutes left. So I would invite you, and maybe we'll start with Peter in the reverse order that we started, for some final remarks and maybe an outlook.
As I said at the beginning, it's the kickoff for the era of private enforcement, but it's not a kickoff for another era of mass litigation. I don't see it that way. We will see considerable changes in this field. We will see enforcement by the DPAs and in court, but all of it until the optimal stopping point is reached, optimal enforcement and compliance stopping point. It will take at least another 5 years and will require 50 or more CJEU decisions, which makes us as lawyers very happy. We won't be out of work. Thank you.
Lots of work for the ECJ. Martin Mekat, please.
Thanks, Julia. I tend to agree with Peter here on many aspects. I don't think that the 5 years are enough. I mean, I won't start singing, but it's a little bit like the Beatles tune. It's a long and winding road, and the ECJ has taken this view that he puts this in the shoes of the member states, and they will need to see how they fill these shoes, and it will take a long time on how this is brought in a sensible shape, and I think there will be lots of, I mean, tens of thousands proceedings all over Europe that we will have to fight, and it will be a long way forward. And I think the way that the ECJ has chosen now, putting this into the responsibility of the member states and then trying to like level it out afterwards, is understandable. On the other hand, I mean, it will be a can of worms for a long time, and it will take many procedures to get this in shape and order. So I think it's like a job guarantee for lawyers in this field.
So maybe we get these tables Paul was talking about. So Paul, you have the chance for some last words.
Yeah, thank you very much for the opportunity to discuss today. I think you certainly inspired some thinking here. What is now important is that national judges understand that they're serving fundamental rights and that the Court of Justice is not just passing on and continuing, let's say, old civil law thinking, but injects a new element in the rights of damages of people when fundamental rights have not been complied with. And let's hope that already now the judges take up this challenge in a way which is in line with the common tradition of our member states in terms of wanting to be countries which protect fundamental rights of people, and where judges also have scope to be part of a learning system which helps to bring the fundamental rights and damages for breaches of fundamental rights into line with the challenges of the age of artificial intelligence.
Thank you very much. Petra, your last words.
Yeah, thank you very much. We don't have much time left. So I basically agree with my previous speakers, and I'll keep it short. So I do think, as I pointed out before, it's a very important judgment because it does keep the chance alive to have effective enforcement, right? To put it in a negative way. It also shows, and here I agree, especially with Martin, we don't have legal certainty yet at all. So it does show also the need for strategic litigation, which is something, of course, like VKI in Austria and also NEUB, of course, at the European level, is willing and prepared to do. And I think this is really important. There are lots of cases looking to Austria alone, test cases. VKI is litigating right now, which can be continued and will be continued now that we have the judgment of the court, of the European Court. And the strategic litigation will try to bring cases and refer cases to the European Court of Justice in order, to substantiate future guidelines, and it will be essential. One last remark, kind of unrelated, but I wanted to mention it, and we didn't talk about it before, is we talked about damages. Very interesting, because now we still have this right to compensation. In practice, it's alive in Europe, right, under Article 82 GDPR, following the court's judgment. In the US, as we know, we kind of have the courts turning down damages cases in the privacy field. So it's a kind of a rejection model with respect to damages. So there are, and also interesting in terms of strategic litigation, there are efforts and litigation concerning unjust enrichment. We already talked about all those illegal profits, really like illegally gained profits via illegally collected data. So this is not in the GDPR directly. It might come into play with regard to calculation, estimation of damages. But under Austrian and German law, for example, so scholarly, I think we don't really have a precedence yet, but it will be a highly interesting issue whether you can use unjust enrichment claims in order to enforce the GDPR as well, which would
way ahead of you.
Which would be scorching the profit.
We have 2 cases pending.
Yeah, so super interesting. More to come. Thank you.
So thank you very much. We're at the end of our discussion. I think it was very, very fruitful, and I think there are also many more discussions to come for future developments of the GDPR right for damages. Thank you very much for coming. Thank you also to our audience, and hope to see you soon. Goodbye.
Thank you. Goodbye.